People feel like once they've set up a living trust, their estate plan is complete. But what we often see in practice is the trust is just one piece, and not always the piece that drives the outcome. Welcome to the Wealth in Transition Report, everybody. I'm Mike DePaul, a private wealth advisor with Newport Wealth Advisors here in Newport Beach, California. Here's what we often see. Someone's done the right things. They've met with an attorney, they've created a living trust, everything is signed and in place, and on paper, it looks like a complete estate plan. But when you start to look a little closer, that's often where some of the disconnects show up. For example, I will often see trusts named as the beneficiary of retirement accounts or annuities, even when there's really no clear reason to do that. And in these cases, it can really limit flexibility or create unnecessary tax complexity compared to naming individuals directly. In other situations, we'll see co-trustees named, maybe two of the children, which sounds reasonable in theory, but in practice, it can really create administrative friction or even tension between family members over time. It's been my experience that a significant amount of the family conflict I've seen can often be traced directly back to lack of clarity in estate planning. We've even seen situations where siblings literally stop speaking, not because of the assets, but because expectations were never clearly defined, or a formal estate plan was not done, or it was done incorrectly. And sometimes it's more subtle. We'll see distribution language that doesn't actually align with what the client intended. For example, let's say someone has two children. One of those children has kids, the other doesn't. Depending on how the trust is written, if something happens to one of those children, their share might pass down to their kids, or it might be redistributed to the surviving sibling, leaving their children, your grandchildren, with nothing. And those outcomes can be very different from what the client thought they had set up. But because the language in trust is often standardized, it's not always revisited or fully understood. And mind you, none of these are necessarily mistakes. They're just decisions that were made in isolation, without fully thinking through how everything works together. Because what ultimately drives the outcome isn't just the document itself. It's how that document interacts with your assets, your tax situation, and how those assets actually transfer over time. And that's where things can start to diverge from what people expect. Because estate planning isn't just about having documents in place. It's about making sure those documents are aligned with everything else, including how retirement assets are structured, how beneficiaries are named, and how decisions today affect both taxes and family outcomes down the road. In other words, your legacy. And for families at higher levels of wealth, this becomes even more important because at the time this video is being recorded in 2026, the federal estate tax exemption is roughly 13 to 14 million per person. So for a married couple, that can be over 25 million. But once you move beyond that, which many of our clients do, a living trust is really just a starting point. At that stage, planning becomes much more specialized and much more dependent on how everything is coordinated. And what we often see is that people feel done once the documents are signed, even though that's really just the beginning. If you have a trust in place, it's worth stepping back and asking, is everything actually aligned with how I want this to play out? And as we know, in higher level planning situations, the objective isn't to add complexity. In fact, it's the opposite, to simplify through clarity and alignment. This has been the Wealth in Transition Report, everyone. I hope you enjoyed it. I'm Mike DePaul. We'll see you in upcoming videos.